The Supreme Court today agreed to a petition which would transfer the petition of 3 men convicted in Rajiv Gandhi's assassination out of Tamil Nadu. The Madras High Court had stayed the execution of these men last year on their plea that the President had taken too long, 11 years, to decide on their mercy petition. She decided against it. The petition filed in court today argued that a fair hearing wasn't possible in Tamil Nadu given the surcharged, hostile and vitiated atmosphere. Every major Tamil party in the state is currently supporting clemency for the 3 men convicted in Rajiv Gandhi's killing.
Over 2 decades after Rajiv Gandhi's assassination, the execution of these 3 convicts, Murugan, Santhan and Perivalan, is perhaps the most politically sensitive issue in Tamil Nadu. Which is why the Supreme Court today decided to take their case out of the state. Instead, it will take over the hearings of the delay in their mercy plea, acting on a petition that free and fair hearings would be impossible in Tamil Nadu due to the surcharged, hostile and vitiated atmosphere.
The petitioner, a local congressman, argued on 2 grounds. One, that the Supreme Court was already hearing cases related to delay in deciding mercy petitions like the case of Devendra Pal Singh Bullar. Second, a more significant argument that the atmosphere in Madras High Court is too surcharged with political leanings.
On 2 grounds. One is the similar issue of Devendra Pal Singh Bullar is pending. As the Bullar's case, 8.5 years delay in deciding the mercy petition, and the same thing was in this case is for 11.5 years.
I don't see any setback. I am confident that these 3 innocent Tamil youths will be liberated from the clutches of death.
Protests intensified last year after President Pratibha Patil rejected the mercy pleas of all 3. The sentence of the 4th key convict, Nalini Sriharan, had been commuted way back in 2000 on Sonia Gandhi's intervention. The convicts challenged the execution, saying the President had taken 11 years to decide on their plea. Hearing the case amid slogan shouting in and outside the courtroom, the Madras High Court stayed the execution and issued notices to the central and state governments. That was on a day political parties, including fierce rivals DMK and AIADMK, threw their weight behind a unanimous resolution in the Tamil Nadu Assembly, asking the President to review the case. The Jayalalitha government later opposed the transferring of the case outside the state, saying only the Attorney General or the parties concerned can file such an appeal. But the Supreme Court today rejected that argument. With A. Vaidyanathan, Chetan Bhattacharya for NDTV.
So has politics really meant that a fair trial in this case isn't possible in Tamil Nadu? Is that a sad day really for India, that sentiment means that the trial has to be moved out of a state? Joining me tonight on that, Soli Sorabji, former Attorney General of India, also Dr. Subramaniam Swamy, President of the Janata Party. I'm also joined by Mr. S. Doraiswamy. He's the lawyer for Nalini. Of course, Nalini's husband Murugan is one of the men who's convicted and sentenced to die in this current case. I'm also joined by S. Nandakumar. Now, he's the lawyer for the man Venkat, a state Congress worker who was the petitioner today. And the Supreme Court agreed to his petition to move the case out of Tamil Nadu. I'm also joined by Sudha Ramalingam, a well-known lawyer in Tamil Nadu and also Vice President of the People's Union of Civil Liberties in Chennai. Thank you all very much for joining me tonight. Mr. Sorabji, your reaction to the Supreme Court decision to actually move this case out of Tamil Nadu. Do you think that given the circumstances, this was the only thing that they could do?
Well, going with the facts that I'm able to ascertain, the atmosphere there was surcharged. It wasn't possible to have a very fair, objective hearing of the matter. It's a very sensitive matter. I believe there was shouting outside the court, inside the court, which made it impossible to deal with the matter in a cool, detached, objective manner. Besides, the other main point was the Supreme Court transferred the petition to itself, because a similar question is pending before it. What's the question? Not whether the people were innocent or guilty. They have been found to be guilty, they are convicts. That's the end of the matter. Question is whether an inordinate delay in disposal of the mercy petition results in commutation of the death sentence into life imprisonment. Now that matter is before the Supreme Court, and it's much better the Supreme Court decides it, Madras High Court deciding it, it ultimately comes to the Supreme Court. So therefore, for these 2 reasons, the surcharge atmosphere and the pendency of a matter in which a similar issue is involved made the court transfer the petitions to itself. Now, I don't think there's anything wrong with it. It's a sensible decision.
Dr. Swami, coming on this point on the surcharge atmosphere, of course, the other case Mr. Sorabji is referring to was of Devinder Bhullar, who again the Akalis and the State Congress have said that he should not be hanged to death, even though he's a convict in a former Chief Minister's assassination. But given the surcharge atmosphere, is the worry that this can be used as a political bogey? Any state government which wants to get a politically sensitive issue like this out of their hands will wash their hands off it and send it to the Supreme Court?
Well, in this case, it's not the government which wanted it. And it was a person in his individual capacity. It's not even, he was maybe a party man, but he is not did it as a party.
The State Congress hasn't backed that.
The fact of the matter is, you see, proceeding before this, the Madras High Court was on, had been closed down in the year 2011 for several months, because a bunch of pro-LTT lawyers didn't want Prabhakaran to die in Sri Lanka, so they closed the courts. All the courts were closed. Then there were a lot of violent incidents, and then Justice Sri Krishna wrote a report which is worth reading, and the kind of elements that entered into the fray. Now, when this trial began, when this matter was taken up, Mr. Vaiko and others organized huge demonstration inside the campus. Outside in Tamil Nadu, there is no support for this. It's only in this handful of people who assemble in these places. It was very difficult, as Mr. Sorabji says, to have a calm atmosphere for where this matter could be.
But aren't politicians actually talking, because they're looking at their votes, so they fear there is a public support or sentiment. Even the State Congress has not come out officially, or the State BJP saying this.
Those are for different reasons. In fact, the prominent pro-LTT people have not won elections. They have lost. The only time they can win is perhaps when they latch on to one of the two parties, a DMK or the ADMK. But the fact is, there's no support for when I was law minister, we dismissed the DMK government. Not one cycle was burnt, leave alone a bus being burnt. There's no support for this. This is when a mob takes over, people become become cautious and they go back into their houses. That's all.
In fact, Mr. Nandakumar, if you can come in here, and as I said, you were the lawyer who fought that petition today on the behalf of Venkat in his individual capacity. When this issue of the surcharge, the vitiated atmosphere, Dr. Swami making the point that this, if it had actually gone through, any government, any strong government can actually control violence or the issue of public outcry if it actually exists in the first place. What is your reading and your client's reading of the situation on the ground? Because of course you know that when the Madras High Court had stayed the execution of these three men, there were celebrations, there were crowds whether brought by politicians or not, but there was the feeling that these Vellore 3, as they've been called, had become popular heroes in Tamil Nadu.
See, my client is a law graduate, and actually he moved it that on seeing there was no conducive atmosphere in the High Court when the matter was heard, and the judicial function was disturbed, and there are a politically motivated group of people, and they have gathered inside the court and inside the campus more than 5,000 people, and they have disturbed the entire atmosphere, and they have made a slogan, and they also fired crackers, issued sweets. During the course of hearing, the government also passed unanimous resolution for commuting the sentence. So this has reached inside the court, and the entire atmosphere was changed. So my client felt it, that since this is the atmosphere in the High Court, so it could be better to transfer to the Supreme Court or any other High Court. And not only for we specifically asked, but 139A of the Constitution prescribes.
No, but
if
this
the similar
even when
issues
the state government had actually opposed this transfer, they said that this request should have come via the state. How can it come from a private individual in this case? Doesn't it undermine, in a sense, the role of the judiciary in Tamil Nadu as well? Because surely the judge will say that he will maintain his independence. This request should have come from the state government.
See, that 139A says that either in suo motu or the representation made by Attorney General of India or the aggrieved parties, or my concern if any of the party, if it bring it to the knowledge of the court that the similar issues like a Buller is already pending for consideration, say in order to avoid any controversy and complicity of proceedings and the orders, it is better for the judiciary to transfer those proceedings and to decide in one place.
Mr. S. Durayasamy, if you can come in here, sir, you of course are the lawyer for Nalini. What is your reaction really to today's decision? Because there was a whole feeling that the mood in Tamil Nadu, the protests we've seen were all beneficial to your client's husband as well. What do you feel? What is your reaction to today's verdict?
The decision of the Supreme Court is wrong. The reason is, the contention of the petitioner is that there was no proper atmosphere in the High Court, and they shouted within the campus, and there were 5,000 people were shouting within the High Court campus is also false. The Supreme Court did not ask for any report from the High Court. Nobody in the High Court made any complaint that there was any shouting and disturbance in the court.
The court has not considered that point.
Not at all in the court. Then the question is that the Bulser's case is entirely different. We are not on the question of a delay of 11 years. That is not the main point. The main point that was the challenge for the High Court is that the President did not consider the facts of the case, and the Cabinet did not pass any resolution also. The matter was not placed before the Cabinet. Unless the Cabinet decides, the President cannot pass an order rejecting the clemency petition. No. The Madras High Court have already, in the matter of Nalini, has decided that the matter should be placed before the Cabinet.
The Supreme Court can also decide on this matter and on this plea. The charge being that the atmosphere is so surcharged in Tamil Nadu currently that there cannot be a fair trial in these current circumstances.
Then can it be see, in Delhi itself there are lakhs of Tamils. Can't they come to the Delhi Supreme Court and create such a atmosphere there? Are they transferring the matter beyond India? In the Supreme Court also the same people will come over there, create shouting. Can't they? It is not a proper decision.
The difference, of course, is about the political parties backing off it, and will that be, how much is this a people's movement and how much is this about political parties also getting involved? Let me bring in Sudha Ramalingam here as an independent legal voice from Tamil Nadu. Ms. Ramalingam, come in here, your views on this.
I think it's really sad to see that people go to the courts, create a commotion and confusion in the campus. I was also there during this hearing in the court, and the premises itself was definitely surcharged. The High Court also, even the hall in which the hearing took place was also in a very surcharged atmosphere. But having said that, I would also like to add that that does not definitely influence the judges who are dealing with the case. The hearing was not tainted because there were people in inside the hall or outside. So to say that the people gathered there would be an influence on the judicial process is something which I just can't imagine it to be true. And the basic principle is that courts are also public places. So courts have to be open to everyone. A court could also have an audience of thousands of people witnessing the proceedings. I don't understand, just because there were a congregation of people, you call them as disturbing the process. Definitely inside the court hall, they were not disturbing the process, but having said that, I would also like to add that this is also not something which is necessary. We will also have to learn to restrain ourselves, and we have to ensure that the judicial process gets along in our own state itself. If the Supreme Court has taken it on itself to take up decide the issue, it would mean that the litigants have lost one chance of an appeal. If this court decides on it, and if there is something which is to be appealed against, they could have gone to the Supreme Court. Right. Now, because of this process, they lose one chance of an appeal.
So it's actually speeded up the whole process in a way which presumably would then have gone to Madras High Court, Supreme Court. Mr. Soli Sorabji, if you can come in here on the larger issues raised in the debate, some worrying issues including the fact on affiliations of lawyers, the conduct of lawyers within the court premises, and also, as Dr. Swamy said, politicians within the court premises. Yet Ms. Ramalingam's point, does that mean that the case should actually be moved out? What happens tomorrow if, say, a case of Mr. Raja is being heard in Tamil Nadu and you have his supporters, the DMK government, you have his supporters there in the courtroom? Would a Raja case be moved out of the Madras High Court? Are these precedents or issues that we should look at as well?
No, Sonia, there have been the past cases where the Supreme Court has transferred the case from one High Court to another. This time it has done it to itself. Why? Because a similar issue is pending before it for consideration. Now that will decide the law, rather than have the Madras High Court pronounce and then an appeal and then again before the Supreme Court. But I want to say one thing. It's not that the hullabaloo in the courtroom affects the judicial process or the judge's thinking. It's a question of administration of justice has to be in public, correct, but in an atmosphere of detachment, quiet and dignity. How do you administer justice when there are slogans all the time? And when there are other activities which really impede the fair and impartial administration of justice. Impartial, I mean cool, detached. So it's the atmosphere which doesn't make it possible. Now you may say that is because of X, Y, Z reason or ABC person. That's another matter that we can deal with differently. The ground reality is this petition, because of the sensitive issues involved and because of the surcharged atmosphere, did not ensure a proper dispensation of this writ petition in an atmosphere which should inhere in every court of law, court of justice. You can't expect a court to really apply its mind and deal with the matter when there are demonstrations outside and sloganeering inside the court. But not the judges are affected in the judgment. It's not possible to carry on that function.
But when you have Mr. Duraisamy making the point that you can have a lakh Tamils gathered outside the Supreme Court as well, what would you say to someone? No, what would you say to a statement like that?
Be done here.
I think that's fantastic.
See,
no one is going to come to the Supreme Court. Delhi is very different from Tamil Nadu. These are local passions incited in Tamil Nadu. There's no question of anyone coming to Supreme Court. Never heard of that. That's completely an imaginary apprehension.
Dr. Swamy, you want to react?
May I say one thing? First of all, this is not a fresh case. The Supreme Court has already considered this matter. Then there was a review petition by these convicts. That was also rejected. And then there was this mercy petition. I don't know why the LTT should want mercy, but anyway, they filed a mercy petition. That mercy petition was dismissed.
But then came the U-turn by the Jayalalitha government, and you had both.
See, Jayalalitha government is constantly making U-turns. There, it doesn't mean anything. It said that resolution was the most ridiculous resolution passed by any assembly. They said, keeping in view the Tamil sentiment, these people should be let free. What about the national sentiment? What about the sentiment that Rajiv Gandhi was killed? Now, that was a ridiculous thing. I think she will live to regret it.
But that's not happening in Tamil Nadu. It's happening in states around the country.
It may. That's wrong. And you should put a stop to it. You should take a stand. I am saying here, this is a question which should not be delayed any further. And it's very good that we have come to the Supreme Court and saved one stage. And furthermore, as Mr. Sorabji pointed out, there's already a similar matter being considered. So why have Supreme Court give one decision and High Court give another decision? And I may tell you that even amongst judges, between Chief Justices of High Courts and Supreme Court, there's always consultation going on. They don't have to make it public.
If you could come in here, Mr. Nandakumar, on the point of how much the political atmosphere in the state is leading to this issue of a surcharge and vitiated atmosphere. Now, of course, your client in an individual capacity, but as a member of the state Congress. It's interesting that neither the state Congress nor the state BJP have really made their stance clear on this at all. Do you think the politics of the matter has clouded the issue here? It's not about public sentiment, but really about political strategy in a sense.
So first, you tell me that what you said, how much. First you started with how many? I have not heard. You tell me how much?
I asked you that is this about public sentiment or is this about political strategy? Do you think the fact that your client is in the state Congress, but he's done this in individual capacity, even the state Congress...
I don't want to criticize anything. Maybe this is a only political scenario. The people, in order to get out of it for the political benefit, and they are taking some part of the group, and they are making to support of it. general concept you can see that no one should interfere with the function of the judiciary. The people, those who are abide by the rule of law, they should leave the judiciary on its own, neither to support, not to support. Even tomorrow, what we accept the transfer, we have nothing to do with this case. But tomorrow what the Supreme Court decides, that is up to the Supreme Court. So here, whatever the people they have taken in Tamil Nadu, it is against the principle which has to be established by the state rule. And whatever the resolution passed, how Mr. Swami said like that, but it is not worthy resolution, or nobody should support like this in open in any corner where the proceedings are pending in the court.
In fact, Mr. Duraisamy, let me bring you in here, sir. As a lawyer yourself, when you make a statement like so many Tamils will protest outside, etc., doesn't it threaten the legal process, something which you are an integral part of as a lawyer?
No, actually I am not telling about the lawyers. I am not telling about the public, those who have gathered inside. And what our senior advocate Mr. Swaraj said like this.
The Supreme Court is, they do not have any confidence with the Madras High Court judges. Otherwise, the case should not have been transferred from the Madras High Court. The question that is waiting for the Supreme Court in the Balsar case is entirely different. Here, they did not make the point of the delay as the main point. That point is entirely different. So the similar case is pending from the Supreme Court is not at all a reason for the transfer. The only thing is that the state government is supporting the accused persons and the entire Tamil people is supporting the accused persons may not be reason for the transfer. Here the atmosphere is conducive.
No, but let me bring in Sudha Ramalingam on what you just said.
State government to look at
do you feel, Sudha Ramalingam, that this order today, do you think it's a lack of confidence in the Madras High Court judges or strong words there?
No.
I think it's twofold. One is, as was rightly pointed out, there's another case pending, and so a similar case could be tried together in the Supreme Court. So they would neither waste time nor would they have contradictory judgments. That would be one thing, one aspect. Another aspect, of course, would be whether there would be real hearing without a prejudice or a charged atmosphere. If it is for the former reason, I would welcome it. But if it is for the latter reason, it is really regrettable, and such things could again be repeated. And in various cases, you could do this repeatedly, ostracize a crowd, and then say this state is not conducive for hearing this case, and keep asking for transfers of cases. It would actually lose faith in judiciary if this is going to happen for this latter reason. If it is for the former reason, I think it's absolutely fine.
Mr. Sarabji, you've been wanting to respond to that strong statement there on the lack of confidence in Madras High Court judges. Go ahead.
Not at all. There can be no lack of confidence in the integrity or ability of the High Court judges. That's a wrong way to look at it. It's because of the atmosphere in the court that judges can't discharge the judicial functions in an atmosphere which is necessary for dispensation of justice. Nothing to do with the personal thing. That ground reality is there. Who has done it, who has created it, is another question. I agree it's regrettable. But in these circumstances, how do you go on with a fair disposal of the writ petition under these circumstances? Court proceedings provide at least postulate a calm, dignified atmosphere.
Dr. Swami, given the current situation, moving it aside for actually from just the purely legal point of view, as a politician, we know that no mainstream politician agreed to appear on this panel tonight. You know, even the BJP, which has said that India is a soft state because you can't hang Afzal Guru, doesn't have the same opinion on these three men convicted also, or of Bhullar. Do you feel that these men will ever hang?
They will have to hang because they killed Rajiv Gandhi. And what did they kill Rajiv Gandhi for? Because he sent IPKF to Sri Lanka. That was a decision of the Parliament of India. You can't kill the Prime Minister of India because you don't like his policy.
But we haven't seen a political hanging.
Well, you've got to start. Many things have started in India. Nobody ever thought that the 2G spectrum scheme will make so much progress. It has started. Now I think it's time to show that we are a tough state. We are not a soft
Will
state.
either the UP or the NDA have the political guts to do it?
Well, they will have to have, and I think certainly in the case of the NDA, if they didn't agree to come, that's a start, because earlier on they were very soft on LTT.
Well, you of course are now part of the NDA now, so let's see how this actually plays out. But of course, Soli Sorabji, Ms. Sudha Ramalingam, Nanda Kumar, Mr. Duraya Swamy and Dr. Swamy, thank you so much for joining me tonight on what's really been an impassioned debate. Let's see how this plays out. The Supreme Court hearing this in July.